Hey Ryan, thank you so much for joining me here today. And I've really enjoyed partnering with you on a number of cases. But what I thought would be a great place to start is if you can share a bit more of your background and how you got to where you are today, serving families in the Charlotte area on estate planning needs. I think that'd be super helpful for me to hear again and for others as well.
Yeah, absolutely. First of all, I appreciate the invite. It's a pleasure to be here, and I can reiterate, it's been amazing working with you and partnering to help some of your clients out along the way. So I'm based in Charlotte, North Carolina. I'm an estate planning lawyer here in town. I have my own practice. It's called Charlotte Estate Planning. Little background on me: I graduated from Campbell University, focused on trust and investment management with a minor in financial planning. After college, went off to work for Regions Morgan Keegan as a trust officer. Unfortunately, went into that career right at the housing bust. So went back to law school at that point, reconfigured. After graduating law school, I went back to work at the First National Bank of Shelby in Shelby, North Carolina, where I worked as a trust officer as well as in-house counsel. Shortly after that, went into private practice, and like I said, I've been working for about 16 years now as a practicing lawyer.
Awesome. Hey, thank you so much for that background and kind of my career started right around the GFC, great financial crisis as well. And I remembered a lot of those life shifts and changes.
Yeah.
Folks were going to school, joining the military, doing something crazy and something different than kind of what was their path was. And you have a really unique background into our world, financial planning, because that was a focus in your studies. But also, I'm always super impressed because you reference a lot in conversations when we do joint meetings about being a former trust officer and what it looks like to be in that seat, even beyond what you're doing now. What's like one of the most expensive mistakes that you can remember? Maybe your time as a trust officer or helping families get documents together before you became, the person helping them to avoid it.
Yeah. Unfortunately, it's a mistake that a lot of people make nowadays as well. I would say the need or the desire, probably desire is the better way to put it, of putting family members in place of as successor trustee in their documents. Unfortunately, you know, family members typically lack the experience, they lack the expertise, they lack the resources to, you know, serve as trustee and
Mhm.
serve efficiently. Most family members, and I get why people do it, it's more of a trust factor. Their brother, their sister, it's somebody they know is going to have the best interest of their children in mind when they're acting, when they're investing. But the shift really happens when, the rubber meets the road. Do they know how to invest? Do they know how to balance a portfolio? Do they understand what comes along with being trustee? It's a lot more than just investing money. Whether it's the legal obligations they have, the obligations to the beneficiary, tax filings, all of that's foreign. Um, so what you can run into is you got family members who have been violating the document that don't even know it. They haven't been, filing taxes as they should be from the trust
Mhm.
perspective. They haven't been distributing income like they should be. And ultimately what that does is it puts the beneficiary in a worse off spot. When I talk to clients today, and even back when I was a trust officer, the big sticking point was always fees, right? And, they didn't want to pay an institution a percentage of whatever the trust portfolio was worth. They didn't feel like that was, necessary thing. And then also that bank or that corporate trustee doesn't know the family dynamics.
Mhm.
So unfortunately, there's a lot to be lost there, and it's not always financial. I've seen it really tear families apart,
Mm.
where you've got a child that no matter how people want to look at it, when they're doing the planning phase, when a beneficiary knows a trust is out there and that they're the beneficiary of that trust, they typically view it as their money. Even though it's not, that's how they
Mhm.
view it. So when they have to constantly go to somebody, whether it's, Uncle Steve, Aunt Mary, and they're being told no over and over, that really starts to create a divide. Um,
Absolutely.
so, I am a staunch advocate of putting a corporate trustee in place. For families that are still apprehensive about that, let a family member serve as co-trustee and leave the administrative process, the legal obligations, the investment piece to the corporate, and then let the family member be sort of the face of the trust of those discretionary distributions, and then understanding the family dynamic to make sure the needs of the beneficiary are met.
I think that's such a big thing that we're big proponents of as well. And it reminds me of a recent case you and I had worked on. We were reviewing some existing documents and we were confirming trustees. And I believe it was that, a family member of this client was a named trustee. And you and I shared all the responsibilities they would have. And does this family member desire and meet those responsibilities, and could they fulfill that? I believe they, cut us off halfway through and they said, "No,
Yeah,
absolutely not.
yeah,
They do not. What do we do
yeah,
now?"
absolutely.
And so we're big proponents of having a corporate trustee, somewhere in line, and it's unique in our setup too, where we can kind of serve in that purpose as having an entity in the background, be that corporate trustee, but also possibly be the steward of the assets around the same time. Talking about existing documents, part of what our team does is we do an inventory. We try and pick up on things that may not be perfect in existing documents. I think one example recently was, unfortunately, someone had accidentally disinherited their spouse. We said, "Hey, it's fine. Your daughter is most likely will allow your spouse to live in the house if something were to happen to you, but legally she would not own it." And they're like, "Wait a minute, how did that happen?" And so we do a lot of inventory of drafted documents before we recommend any changes, and then getting you in the conversation. But I'm curious, for folks that think they have things in a good order, or maybe they got documents drafted 10 or 15 years ago when they first got married. What's something you see wrong in a lot of those documents that you pick up on quite frequently that does prompt a change in a quick order?
I would say, well, it kind of depends on what the basis of the planning is. I mean, there's a difference between will-based planning, trust-based planning. I would say some of the bigger issues that I come across are when it comes to trust-based planning. One, do the clients know they have trust? I mean, and this is
Mhm.
independent of folks that we've worked on together. But I had a couple that was in my office a couple months ago that they had very old documents. I think it was from the late '90s, and they both had trust set up and had no idea. Um, so from a trust based perspective, I think funding the trust is what a
Mhm.
lot of people drop the ball on. After their documents are set up, they don't go back and fund their house into the trust, any other real estate, fund financial accounts into the trust, or at least make the trust beneficiary. And you kind of, if you go that route and you don't fund the trust, you're losing the benefit of the trust for,
Mhm.
in most cases, because the point that people arrive or come to when they set up the trust is, I want to avoid probate. I want this to be private. If that trust isn't funded during your lifetime, you're missing that. The
Mm.
trust is only going to get funded after probate through their pour over will. So that's a big miss. I mean, I see it all the time. People may have a trust. They may have put one asset in there, but the bulk of their assets still remain in their individual name. And a couple others would be beneficiary designations.
Mhm.
I think people they may set those up when they open an account and then never think about it again. So when you're going back and now doing your estate planning, it's important to put those designations on the forefront and make sure everything's aligned. And another would probably be distribution schemes in general. A lot of folks I talk to that are older, they set their documents up one way because their kids were young. And now they, we're revisiting things and they go back and read the document and it's nowhere close to what they would want now. They may want their children to receive everything outright now instead of being retained in trust for life or for a certain number of years. So I tell clients every 3 to 5 years, right? Go back,
Mhm.
take a look at your document or documents, and does it still fit with where you are in life and then what you ultimately want to happen? Because I tell people all the time, and unfortunately, I have to have a conversation about dying over and over. Is we never know when that time's going to come. So make sure things are aligned with how you feel comfortable today. We can always fix it or change it down the road.
I think that's huge because when we do a beneficiary audit, when we onboard a family, how are the 401ks? What are the beneficiaries there? The IRAs, the non-retirement accounts. And there's this assumption, well, no, I created this trust over here 10 years ago, and surely that's where everything's going to go. And part of what we do is some education on, hey, okay, these are the accounts that pass by contract with a named beneficiary, right? We can name the trust, but sometimes they're legacy accounts at a former employer, and there's not that full look back as folks act begin to have more and more accounts, workplace retirement plans, IRAs, non-retirement accounts. And so that's our first thought is when we onboard a family is we'll do an audit, which ones are assigned correctly. And if there is a trust document, that's great. And another piece on the trust document that we are picking up on frequently that Ryan has been awesome in helping folks with growing families realize is when they got their trust documents in place and they have certain things assigned for the kids, those kids were very young in age. Maybe all of them in the picture now weren't even in the picture when they drafted those documents. And I know with my kids, they're 13 and 9. I have a degree of who's a saver and who's a spender at this point. Who knows that could flip at some point.
Yep.
And it's always wise, like Ryan said, to go back every 3, 5, 7 years and say, okay, is this a child that if something were to happen could inherit a large sum of money at a very young age, or possibly, maybe we want to protect some assets and not push them out at certain points in time where we have no idea what type of marriage they're going to be in at a certain point in time. So allowing as much flexibility, protection on those trust assets as possible has been a huge benefactor working with Ryan and his team because he's able to identify, there's a big difference between a word shall and may, right?
Yeah.
Shall forced out. May provides a lot of flexibility in a trust document. And I know that's getting a little bit in the weeds, but that's just some real life scenarios we've been through where we're auditing former documents drafted when the kids were young. Now the kids are approaching college, and there could be a difference or dispersion on how assets should be sent out at different ages,
Mhm.
providing a lot of flexibility in that trust document that could actually be really enhance credit protection as well as enhance superior amount of privacy.
Yeah, and I
I
think
think
you nailed it with, as kids grow up, they get married. You don't know what kind of marriage that's going to be. Is it going to be for the long term? Is it not? So, as children grow, I think it's important to revisit probably a little more often, right? Because like you just said, the temperament may change, right? They may be a saver today, but not tomorrow. They may marry somebody who has ulterior motives, if they
Mhm.
know that there's large sums of money out there. So different levels of protection apply for different children. I mean, that's another big thing is, I get clients that come in and they think that if I set it up as far as a distribution scheme, it's got to be the same for everyone. And that's not the case, right? I mean, you can take each individual child or beneficiary's temperament, ability to manage money all into account when setting this up. So it's not just a form based, like, okay, I put their names in, it's 50-50 or equally divided, and that's it. And I sit and forget. I think that's the biggest mistake people make is they may set documents up 10, 15 years ago and they think it still meets my ends. So I don't need to bother looking at that. And I just that's the wrong way to approach it.
Yeah. I think also, what I've appreciated working with Ryan and your team, Ryan, is, once you do get to that end part, you provide us counsel in the, you call it family CFO role. These accounts need to be placed in the name and trust. These beneficiaries need to be altered or changed. And we'll prod folks to get that stuff done. But I think that's also one piece where if you get documents drafted, in some type of other manner, not by using an estate planning attorney like yourself, you're not necessarily going to get that prompt, that prod, that kind of poke to say, okay, we've done all this work, to your credit, to your point,
Yeah.
we've done all this work. Let's get it over the finish line. If we could switch gears just a little bit, kind of to jog your memory, Any recent cases, or maybe kind of talk through in theory what happens if there's a discrepancy between a beneficiary designation versus maybe what a will says,
Mm.
and kind of some of the dangers in that and some of the challenges you've seen play out in families?
Yeah, so I mean the ultimate thing is, or the thing to keep for people to keep in mind, is the designation on the account is going to control, right? So if you have beneficiaries set up one way on the account, but then let's say your will is distributing your estate in another manner, the account's going to control. And the reason for that is that designation is passing, like you said earlier, via contract, and it's passing outside of probate. The will is only going to touch items going through the probate process. So
Got it.
you're automatically circumventing probate with beneficiary designation. So it's always important. I tell people all the time is go back, look at the beneficiary designations you have on accounts. Because if that's how you want it, then let's set up your estate the same way or something that's going to closely mirror that. The other piece about that is that people frequently misunderstand is that account is now going to transfer to the beneficiary outright. So if you do have concerns about whether it's a spouse or it's just the child's ability to save and spend money wisely, you're now giving them a lump sum of money. And do you understand that? Are you okay with it? Um, I think when you talk on those levels of one, this may conflict with what your documents say, and then two, are you okay with the beneficiary getting that money outright? People kind of sit down and take a little bit longer pause
Mhm.
to make a decision on what they want to do. Um, the other thing that I've started to see is when it comes to the beneficiary designations, people don't understand that, they may put their spouse as the beneficiary on an account or a child, but nobody after that. So
Mhm.
if that person predeceases and you never go back and update your beneficiaries or, don't have backups before you lose the ability to make those updates, that account's now falling back into probate, which is the whole process you were trying to avoid in the first place. So, it's a kind of reoccurring theme of go back, see what you've got in place. Does that align with your goals today? And then also, are your documents working in unison or are they competing against each other? Um, you know, Kind of off topic from what you asked about beneficiary designations, but I always get a little pushback when people are talking about their will versus a trust.
Uh-huh.
They think that they need a long form will in addition to the trust, but the problem you run into there is if your will says one thing, the trust says another, now what's controlling? And that's where potentially litigation has to happen. Now you're going to cost the estate more money by hiring lawyers, going through that process. And then you're ultimately delaying where these assets are going to go and when they're going to get distributed to the beneficiaries. So, you know, detail is a huge thing when it comes to estate planning. The more detailed you can be, the less conflicts you're going to have down the road, whether that's between documents or people within, the beneficiary designation scheme.
Got it. And, for, a lot of the families I serve, mid-40s, mid-50s, peak earning years, they have a lot of demands. They're busy doing other things and thinking about these items. That's where they have folks like yourself and myself to kind of jump in and help on these things. If they got, if that person or that couple, that family drafted documents 10 plus years ago, what document do you think they should kind of pull up and take a glance at right away? And then after that, kind of what would that next step be? Like they'd be looking for on that document that you think they should look at first to make sure things are done appropriately and take a next step.
So I guess I have to bifurcate this into the different types of planning. So a will, what you're going to look at there, if that's your dispositive document,
Hmm.
meaning that's what's distributing the estate assets. One, you're going to look at the distribution scheme. Is it still what you want? Um, a lot of factors go into that, whether it's just the beneficiaries in general or what assets you are ultimately going to pass down to either your children or other beneficiaries. Executors is another big thing. A lot of people that may have drafted documents if they're in their 40s, drafted documents 10 plus years ago. They may have named their parents in that role or some other older family member.
Uh-huh.
Odds are those people may be getting to the age where they just are physically unable to do it, whether it's health or they're just, everybody's transient now. People move.
Really?
So, if you're born in New York and you moved to North Carolina, are your family members you've designated as your executor going to have the wherewithal and the ability to constantly come down to North Carolina to achieve the goals they have as executor? Answer to that's probably going to be no. And then also if people passed away, right? Because if they have, whether it's an executor or a beneficiary, let's reconfigure this so you still have backups in place. You have, an alternative distribution for your assets because we already know beneficiary number 2 is no longer in the picture. So now where are we rerouting that? Back to the will, those folks may have underage children, guardianship's going to be a big thing. In North Carolina, the courts do the best job it can in honoring what the parents want as guardianship for their minor children. Um, the only time they're going to deviate from that is when it's not in the best interest of the child to go to that particular guardian. But making sure you have people in place and you have backups is huge. Because that's the last thing, in my opinion, you want the court trying to figure out is who's the best fit to take
Mhm.
over, caring for your children. That's a lot bigger task than managing money. You can bring professionals in to help you manage the money down the road, but raising kids, you want to make sure it's in a stable, safe environment, and you want to be, you want your finger on the pulse on controlling those folks that are going to go into that role, not the court system.
You you got it, and, something we always, try and educate folks, there's executors one role, right?
Yep.
The beneficiary, the folks that receive possibly the assets as named in a will or possibly a trust document, 2 different things, right?
Yep.
With a will, the named executor, and then there are named beneficiaries, or if it's trust, there's a trustee, and then there are named beneficiaries of the trust. And it's kind of identifying those key roles is something that we think is super important. And I always joke around, which with folks, kind of that's more so related to healthcare power of attorney and financial power of attorney. I say, hey, I would love and I think it would be awesome for my brother-in-law, father-in-law to help out with financial power of attorney related issues, but I would not want them making my healthcare related
Yep.
decisions. If I'm in the hospital, and usually get a joke or two or a laugh or two out of that. And so I think it's very important to flow chart out who those key roles are. One family recently, and I'll kind of use some sub-in names, not disclose any information, but we did a flow chart of their existing documents, and one of their sons, we'll call him Billy. They're like, well, where's Billy on this? Isn't he there? No, he's just not. I don't know why. I don't know when these were drafted or
Yep.
why he's missing. And so sometimes just putting all the names out there on a simple flow chart can be of help in seeing who the named executors are. Should they be that person? Are they a responsible party in your life that can execute? And then secondly is that flow of distribution of assets, that you mentioned. At what point does it get more complex? So I'm thinking, different assets that are owned, different levels of net worth, possible maybe someone moved from one state to another and then they have residence elsewhere. Obviously, we're North Carolina. We know the importance of having documents drafted in the state you live in and having originals. But at what point does the asset level or net worth of someone change how you approach what you consult folks to do at certain possible income or net
Mhm.
worth or asset based levels of net worth?
Yeah, I mean, net worth, we're kind of at this stage right now where the federal estate tax exemption is untouchable for most folks. I mean, it's 15 million for an individual, 30 million for a couple. So until you have a dollar above that, you're not paying federal estate tax. North
Got it.
Carolina does not have a state level estate tax, so that's not a drafting concern right now. Again, laws can always change, but I would say the complex planning isn't so much related to net worth anymore like it used to be when those levels were lower. It's now assets, right? So family businesses, very unique assets like I've worked with people that have a bunch of timber. They need, they've got REITs, real estate
If
investment trusts. They've got land trusts they're invested in. So that gets a little more specialized. Small businesses or family owned businesses are the biggest thing now.
got it.
And it's not so much that there's difficulty in transferring the asset or moving the asset. It's trying to equal out. Like, so if somebody comes to me, they want their kids to share equally, but maybe only one kid's invested or working in the business. The other kids don't want to have anything to do with it. Now we've got to figure out other ways to try to even out the distributions, because if they want it evenly, we know child one's getting the business that's valued at X number of dollars. How do we even things up for the rest of the children? Um, so I think getting creative there is a big thing.
Mhm.
I don't do much with Medicaid planning or elder law planning. That's another specialized area, but that's a big, upfront planning piece, because there's all, the look back periods, there's the clawback provisions. So you really want to be proactive there. But in my world, it's more about what are the assets we're talking about. That's
Got it.
always the first phone call I have with people is give me a rundown of the assets. Because I need to know in my head, is this something we need to get creative with, or are we just dealing with pieces of property in different states? That's not a huge deal
Mhm.
unless they're unclear on how the property is owned. Because there's a big
Got it.
difference between somebody moving from a community property state like California to now being in a separate property state like North Carolina. And then, what are the proceeds from these properties being used for? And does that create title issues down the road for other assets? So kind of keeping them on track with title ownership is a big thing. But I would say, specific assets are the biggest thing now, where we
Okay.
and it's not so much income isn't something that's going to bother me or be a drafting issue. Because again, as long as we stay on top of the tax law changes, where's that net worth, we can plan accordingly. I tell people all the time that, we don't know how permanent the current legislation is going to be with the federal estate tax. So, when I was going through school, it was 1.5 million. Um,
Wow.
so, there were a ton of people that needed irrevocable trusts. They needed life insurance trusts to try to soften that burden of
Mhm.
federal estate tax. Today, much more difficult to get there, but that doesn't mean those lines may not intersect down the road. So that's where staying on top of the estate plan updates. Where are you today? What's your net worth today? What inheritances are you and your wife expecting? Those are, or your husband. What is it that we need to plan proactively for? Because ultimately, the minute they lose testamentary capacity, we're stuck.
Mhm. Well, I think you had mentioned family business and land, and just attended, along with our team, Queen's University Estate Planners Day. And for those that, are looking for something to get on the calendar for next year and you're kind of in this line of work, would highly recommend it. But they had one presentation that was reviewing all current cases, right, that could help kind of dictate how, future hearings could go. And almost every single case was children inheriting assets and having a disagreement amongst the siblings. Who owned what piece of land, or was this dispersed properly, or contesting trustees, or documents changed later in life and that the other siblings weren't aware of. And it was very interesting just how similar each case was, and it almost always was the pass down of the family business or possibly division of hard assets and land across a group of siblings.
Yeah.
And that's why I always desire at the end of a planning process, if an attorney recommends a trust, or like a revocable trust, we're huge proponents because it's a document that folks can go back and change and alter as long as it's in that revocable fashion throughout their entire life. So if one child makes a decision that doesn't jive too well with the parent, or possibly need to have some type of special provision for, a child that may have some type of special needs or something unique to that family that happens later after the document's drafted, being revocable in nature, they can always go back and change or alter it, as life progresses.
Yeah.
Life doesn't stay the same. Family dynamics change.
Yeah.
folks coming in and out of your life that
Money
may
in
have
general
once.
changes
Yeah,
people. I mean,
you
it's
got it.
I mean,
You
you
got
nailed
it.
something that's important, right? And I get people, and this is a red flag to me when a client says it, is when I start talking about distribution schemes of, where do you want stuff to go, or particular investment properties or personal property, like whether it's watches, jewelry, things like that. Oh, the kids can figure it out and decide amongst themselves. And if you want to talk about a recipe for disaster, that's your number one. That's your number one issue that I see. Folks that come into my office, they're under this assumption that the kids get along today, that will carry them through this process. And it 9 times out of 10 isn't going to work, because at the end of the day, there may have been a side conversation that one child had with a parent that they thought they were going to get X, Y, and Z, and now they're not, or the other sibling wants it. And now who is this neutral third party that's going to help them decide? When ultimately what we could have done is been detailed in the planning process. And now you're taking that argument off the table and they don't even have to deal with it. So it's thoroughness, detail. I know that scares a lot of people, but it's going to save a lot of heartache and potential rifts within your family down the road by just taking the time. I mean, it's not, if you're hiring a lawyer, use the lawyer as a resource. Don't assume it's, one of these web based platforms where you just answer
Mhm.
a questionnaire and then it spits out a document that fixes everything, because that's just not the reality. Part of this job is planning for the contingencies, right? And we don't know what they may be down the road 10, 20 years from now. So let's try to
Mhm.
figure out as many of those as we can collectively. And that's what, I've appreciated with working with you is, you guys take that measured approach, and it does wonders for your clients. So, I can definitely give kudos where it's due.
Well, let me jump in there. What do you wish that financial advisors as a whole in an industry understood about estate planning that would make uh, not your job easier, but just make them more aware of catching issues before they take place? What are some key things that you think advisor teams that are serving in that family CFO role should be doing?
I mean, I will say I think I'm kind of lucky with the folks I work with. Everybody, is pretty thorough, but I think with younger advisors, they have tunnel vision on, these are the assets or these are the portfolios that I manage. Beneficiaries are key. And there's this fixation on dying, right? Like, what is going to happen when you pass away? There's other planning that needs to happen for the client, right? I mean, there's a number of things that could happen to the client that don't end in them passing away. Are
Hmm.
they gonna be cared for? Are the right people gonna be in place to manage their money for them for the rest of their life? Um, so, I think taking a wider view of what does this family have beyond what I manage, and let's make sure all of these efforts are aligned in the right way is probably my little piece of advice that I would give people. Simply because I have to see it all when I'm doing the planning. And, it can't, if you're focused in on only the investments, there's a lot of other stuff that could be missed out there. And it's not intentional by any means. It's just, that's what you're managing. That's where your performance is based on. So I
You got
get
it.
why that would be the focus. But I think folks that look at it that way are doing a disservice to the client, because there may be things that fall, you know, by the wayside that we could have planned around, we could have dealt with, or at least counseled them on so they know what the repercussions of their decisions are going to be.
Well, I mean, it also reminds me, I love to talk shop. I love the investments. I love markets. I'll kind of go there with folks all the time, right? That's where my natural state is on a daily basis. But sometimes I think about like what's the best thing or biggest impact item, and it's something as simple as, hey, let's just talk through some medical directives, because a lot of times folks will sit in front of me and they say, hey, you know, I don't care, when it comes to that stage, just do this or do that. And it says, hey, sounds great. Sounds like you've communicated that to your family. Let's make that official, right? Let's go ahead and select that option when we're drafting documents. It's not an easy thing to talk about, right? Near being of life, but I always encourage folks to take that next step to actually make that change in their documentation, because all you're doing is taking that pressure off of a son or daughter in the future, to not have any type of guilt based on
Yeah.
decisions they make when you're near end of life. The term, draft a family love letter is thrown around quite often, but I think sometimes when I'm sitting across from a family, Mr. and Mrs. Client, the best family love letter you can give to your kids right now is to make sure you make your wishes known to them, draft the appropriate documentation. So if and when that time comes, they move forward to that point. Hey, mom and dad made this decision. They were proactive, and that is a great love letter that you can give onto onto your
Yeah.
kids,
Yeah.
onto your family.
Yeah. Yeah, I mean, I agree completely. I mean, you gotta think when somebody's in that stage of end of life, um, the kids or other family members are already dealing with enough. So to then
Hmm.
burden them with end of life decisions, that's tough. The other thing you kind of touched on was, and I hear it all the time, I told my son or I told my daughter this is what I want to happen. That's great. If your son or daughter doesn't have the document to have the authority to make those decisions, there's not a hospital in this country that's going to listen because at the back end of it, they're facing litigation by taking medical advice from somebody who wasn't authorized to provide it. So I think a lot of people they're looking for the informal way to handle things instead of let's get these documents in place so that your family, while they're dealing with this issue, don't have to run to court to try to get appointed as guardian. Who knows how long that's going to take? And all while this is happening, no decisions are being made. So again, proactive, right? That's always the better approach instead of reactive.
Got it. Got it. What's like one big question you think families should be asking that almost nobody thinks to ask? What would you leave families that are growing fast in far as net worth, their time's diminishing, their net worth is increasing based on just being good at their job or the business they run? What's one question you think that your family should come away with this thinking, and what should it prompt next from an action standpoint?
I think what a lot of people, and I'm going to take it from the perspective of when I sit down with folks and we're starting at
Sure.
the front end of the process is what happens if things don't go as perfectly as I hope, right?
Mm,
It's always the dream scenario of my children are going to survive me. They, are going to have grandchildren if they don't survive me. So everything is going to kind of trickle down to my descendants. My family line down. But what if, God forbid, things don't shake out like that? Now what? When I ask that question to people, of where would you want your stuff to go in the event your children predecease you and there are no grandchildren involved? Now who's going to receive the assets? And the blank stare I get is more often than an answer. When I sit down with people, I'm always playing devil's advocate. I know you want it to go here, but what if something prevents that? Now what are we going to do? So that should be the question is, when whether you're sitting down with me or another estate planning lawyer, the question should be, okay, I know we've drafted this to go to my children and down through the family line, but what do we do if there's nobody there to receive the assets? Now who is going to benefit? Because in all likelihood, there may be friends, there may be extended family, there may be charities, there may be schools that they would want to receive those assets if nobody in their bloodline is alive to receive.
mm.
So the contingency planning, I think is something people leave out because their sole focus is this is going to work out exactly like I thought. But unfortunately, more often than not, something becomes an obstacle along the way. So what can we do to pivot? And ultimately, like I tell people, because when they don't have an answer, my response is, are you okay with these assets potentially going to the state of North Carolina? Because if you have failure of beneficiaries, that's
That's
what's
what
gonna
happens.
happen.
Yeah.
And nobody to this day has said, "I'm okay with that." So, you know, take time to talk through all of the different scenarios of what if. What if this child passes away? What if there are no grandkids? And then let's plan from there going forward.
And that's great. And Ryan, I've enjoyed when we partner together, how you create and partner with families in more of an open forum meeting, meaning like come back to me, right? Think about it, have a coffee or a glass of wine and think about these named key individuals. Come back to me with more questions, kind of in that more consultative role versus where I've seen in some cases, no fault is more of an order taker mentality, kind of, you know, what are these three people? Let's put them on a sheet and then have documents drafted shortly thereafter. So I really do appreciate that devil's advocate role that you serve and allow an open forum for folks to come back in a continual manner while they're drafting those documents.
Yeah,
Thank you so much for your time. And this is going to be hugely beneficial to the folks that I serve. And we just want to make sure families are in a good spot to make sure they have the key documents in place and the beneficiary designations are exactly as maybe you would desire them to. And for everyone that is tuning in, me personally, we got documents drafted and we had an uh-oh moment shortly thereafter where it's like, oh man, we can't have our documents drafted in this way. And we went back to the well and got things adjusted quickly after. So it's amazing, even when you do put a lot of thought into these documents, how life
yeah,
changes, family dynamics change, folks come in and out of your life that may or may not be a part of these documents. But it's also important to revisit them on a consistent basis, and that's a lot of what we do with the families that we serve.
absolutely.